From the main list, item number 1.
This lordship.
Who's for the first respondent?
Lordship. First respondent.
You are for the first respondent? Yes. What is the matter about?
In this case, it is a leave application filed because he was not the party before the single judge. He filed an application for.
How are you aggrieved? Let us see the orders.
Your lordship.
You are seeking leave to appeal.
Lordship. Because I was not given a party, but however I was affected by the order passed by the single bench, lordship. The page 59, para 59, page 151, lordship, where this is some direction was given.
(151).
Lordship. Para 59.
How are you affected by this?
Lordship, if I may come to the, they have filed the FIR against me. There is a serious allegation against me also, saying that I have involved in killing the private respondent's sons in the fake encounter. So they array me as, they said that I am the police officer. So
You are not a party?
I'm not a party in the repetition, lordship. However, there is a serious allegation was made against me, saying that I'm the police officer, and I'm the accused number 1 in the first one who shot the son of the private respondent number 1. And then there was a FIR against me and also against the sumoto FIR by the police, and then that FIR has been.
Where are the prayers in the repetition?
Prayer in the repetition, lordship. It is at page. This one. Page 61, my lord. It's continuing from page 60 to 61. There are two prayer, lordship. First, that you want that case should be transferred to CBI. Another, they want the adequate compensation have to be paid to the disease.
It's only an investigation. How are you affected? If you were not involved, you were not involved. How are you affected?
No, lordship, because now they have given the case has been, the direct direction is given to the CBI.
Yes, CBI will investigate. You have done nothing wrong, according to you. So CBI will not file a charge sheet against you. How are you prejudiced? Investigation would have been done by a local agency, investigation by the local police, investigation could have been done by the CID, investigation could have been done by a SIT constituted by the court or by a central agency, the CBI. The court deemed it fit to give it to a central agency, so the local people were not involved.
Lordship, the investigation is already done by the CIT.
Maybe. The court deemed it appropriate for a fresh investigation to be done by the CBI. How are you affected? Whatever, if they file a charge sheet against you, you'll have to fight it in accordance with law. If they file a final report against you without framing any charges, you're absolved. Investigation. There is no prejudice in this.
Lordship, my contention was because
And the compensation that they seek from the state. They seek from you.
I'm not agreeing on the compensation. I leave up to the government. But only thing is that since investigation has been completed, then the court also that 2 FIR was filed. That as per the court that is already been completed. Now again another CBI it will be an amount to the harassment to the.
That you face. The court has that discretion, a constitutional court has that discretion. It's exercised the discretion, it's found prima facie that this was the case. We say that this order will cause no prejudice to you in course of the investigation. That much only, nothing more.
My Lord,
Who are you?
my Lord, I am the state. My Lord, against the same order, my Lord, that is Imperial Order 25/2023. State also has preferred an appeal. That is listed at item number 3, my Lord.
Yes.
So these are two connected.
What do you have to say?
My Lord, if I can explain regarding the case little.
Yes.
The brief facts, my Lord.
Yes. Yes.
My Lord, the brief facts, my Lord, is that on 3/3/2015, my Lord, there was a reliable information that was received by the police, my Lord, that 3 hardcore GNLA militant under the leadership of Zarek Momin and 2 newly recruited cadres have taken shelter in Romba Adangiri village with intention to extort money from the business and government official and to kidnap for ransom. After, my Lord, on this information, the Inspector B.N. Marat, my Lord, along with other police personnel, my Lord, they left for counterinsurgency operation at around 3:30 a.m. on 4/3/2015, my Lord. At about 5 a.m., my Lord, the search operation commenced, and during the course of the operation, my Lord, the party spotted a suspected house near Romba Adangiri village, and thereafter, my Lord, the police, they have cordoned the area and they have given warning to the person inside the house to come out and surrender. But they have not surrendered, they did not come out. And a person by the name Samson A. Sangma from the nearby house, my Lord, he wanted to go and open the door of that house, particular house. But police, my Lord, after being fearful about anything might happen, they have called that person, called back. And thereafter, my Lord, immediately after that, my Lord, the 3 persons out of that same house, they broke open the door and then they went firing to the police.
They broke open the door, they were inside the house.
They were inside the house.
Yes, and the house was locked from outside.
My Lord, these are bamboo-made thatch house, my Lord.
Very well.
They just came out with a gun and then fired to the police, my Lord. In retaliation, my Lord, police also had to open their fire, my Lord. And my Lord, in this process, my Lord, what has happened? A person by the name Sangbat Marat, my Lord, he got bullet injury and succumbed to that, my Lord. Now, after that, my Lord, from the body of the deceased, nearby area, my Lord, a pistol was found along with 1 magazine and live ammunition, my Lord, and GNLA demand note, 1 detonator, mobile phone, alcohol, SIM cards, and other things, my Lord, which were recovered from the area where the dead body was lying. And thereafter, my Lord, inquest was conducted and FIR was registered and the complainant was B.N. Marak. And thereafter, my Lord, postmortem also was...
Is the father of...
B.N. Marak, my Lord, is the police officials, my Lord. IO. And my Lord, thereafter, my Lord, postmortem also was conducted at Tura Civil Hospital, my Lord, on 5/3/2015.
What was the age of the deceased?
32 years, my Lord.
Very good.
And my Lord, on 5/3/2015, my Lord, a preliminary report also was sent to the NHRC, my Lord. And thereafter, a detailed report was sent to NHRC on 6/3/2015, my Lord. And then, my Lord, the weapon which was seized, it was sent for FSL. And the FSL report also confirms it is in serviceable condition. And, my Lord, thereafter, the Tura PS case number 53/2015, along with another case, my Lord, Tura PS case number 55/2015, which was filed by the petitioner here, my Lord, in that case, the Abal Sangma, my Lord. These 2 cases were handed over to CID, my Lord. Now, FSL report, my lord, it confirms that the detonator, my lord, which was seized from the place, my lord, where the dead body was found, or from the house, this detonator is alive and it can be used to explode high explosives. And thereafter, my lord, the FSL report also confirms the gunpowder residue in the hand swab, my lord, which was taken from the deceased. And my lord,
What was taken from the deceased? In the hand?
from the hand swab, my lord, which was collected. So it confirms, the FSL report, it confirms that there is a gunpowder residue now. And my lord, what has happened is, in the meantime, the petitioner in the other case, my lord,
Now, what happened to the human rights case?
my lord, nothing, they did not find any incriminating things. my lord.
No, have they closed it?
Yeah, my lord, they have not registered any case also.
No, they may not have registered any case. Has the matter been closed by the Human Rights Commission?
My lord, that aspect, my lord, I need some confirmation. my lord.
Very well.
Now, in the meantime, what has happened, my lord, the petitioner, who is the father of the deceased, my lord, he approached the Honorable High Court by WPC 83 of 2015, seeking for compensation because, as per him, my lord, there was excessive use of force, my lord, by the police personnel and for CBI inquiry. And the Honorable Court, my lord, single judge, by order dated 28/6/2016, my lord, 2017, directed inquiry by the learned district and session judge, Tura. And my lord, the learned district and session judge, after conclusion of the inquiry, it comes to the finding that the encounter was genuine encounter. It comes to the conclusion, and that report, my lord, was never been challenged till date. That is still exists. Now, my lord, the learned single judge again on 2/5/2023.
No, that petition was disposed of.
That was pending, my lord. That was pending. In the meantime, the court has directed for an inquiry by the learned district.
And that report was before the court.
It came before the court, my lord.
Yes.
It was submitted.
And what has the court said about that report in the judgment?
Nothing, my lord. Did not say anything.
Court has not referred to that report?
No, my lord. It did not consider the report, my lord. That interim order is here only, my lord.
Show us the order by which the report was asked for and show us the conclusion in the report.
My lord. My lord, will kindly come to page number 162.
Of your papers.
My lord. The order 28/6/2017, it starts at page number 1.
Just a second. On 28th of June 2017.
Yes, my lord.
And then ultimately it was by judicial officer from the judicial side.
Right.
Very good. Very good. And what is that report?
Report is page number 163 only. Next page, my lord. It starts from next page,
Just bring us to the conclusion.
my lord.
Finding the
Right. My lord, page number 187, my lord. Paragraph 36, my lord.
paragraph.
36, below portion, my lord. I'll just read out, my lord. It can be seen.
From that the source of information generally in the center was most probably a correct information as the deceased was found lying, trying to escape by running away and shooting with his gun, and the subsequent recovery of the gun note and pocket recovery from his bachelor's dormitory. The presence of two other persons with disease was said to have been established. This is further days of the incident. Impugned judgment is here.
Yes, my lord. That is at page number. It starts from page number 35, my lord.
Please come to paragraph 46. At page 55. Magistrate
Yes, ma'am.
Marak, who is in the BDO, Rangram, reached the PO at about 10 to 11 and along with IC Baman and other police personnel entered the house. The door, which is made of bamboo, was not broken, and inside the room some bottles of foreign liquor was found, as well as some papers and part of a detonator were also found. This witness has also noted that at the spot where the deceased son of the petitioner was found lying face down, there was a slope below the house of the deceased, and the indications of a person who might have tumbled or skidded through the slope. Such skid mark or slip mark showing signs of only one single person running towards the place where the deceased was lying. When he checked the body, he found many entry wounds as well as grazing bullet wound on the body. Maximum targeted wounds on the body being at the back and buttock area.
Yes.
This witness also saw one old pistol which appears to be a country-made pistol with a Jan magazine just about a few meters from the body of the deceased. I.C. Baman picked up the pistol from the shallow water of a nearby stream and checked it in front of him. He tried to take out the magazine but could not do it. As it was hard to take it out, and he has to use stone to remove the magazine. There were 2 bullets in the magazine and the pistol seemed rusted. While appreciating the evidence of the witness and also the FSL report, the district and sessions judge has relied on the FSL report that the country-made pistol is found in serviceable condition and gunpowder residue which was detected in liquid in a plastic is the hand swab of the deceased, and also gunpowder residue detected in 2 cotton swabs found at the residence to come to the conclusion that the deceased had fired from the said gun which was seized. The fact that the deceased had also failed to surrender but had run out shooting in the direction in a bid to escape, upon which police has also been confirmed in the conclusion of the inquiry. There is, however, an observation that police should have exercised restraint once they have seen the suspect have fallen, which only goes to show that it was accepted that excessive use of force by police had taken place. Then comes the reason. On the analysis of the observations made above, what is clear is that there are 2 versions of the sequence of events which occurred on the date. One on the part of witnesses who are residents of the village and another from police personnel who are also part of the operation. Absolutely justified. Absolutely justified. What you are saying may be correct. Let the CBI find out. They'll give you a clean sheet. You will not have this slur on you.
My lord,
We are not jumping to any conclusion. Neither has a single judge.
my lord.
But he has found, and it was wrong. We asked you, how is he dealt with the report? You said he has not.
No, my lord,
He dealt with in great detail. No.
My lord, as far as the finding of my lord, the learned single judge, as regard to the 2 versions, my lord, is aware that honorable courts, my lord, it has laid down parameters under which CBI inquiry can be directed, my lord. At least, my lord, there has to be some sparingly some exceptional situations, my lord, wherein, my lord, the incident may have some international or national ramification, or there should be prima facie, my lord, some material, my lord, which can come to the conclusion that there is need for such an inquiry.
No.
But
no.
in this case,
there is need for such an inquiry when there is evidence on record. Evidence on record which shows the nature of the pistol. There is evidence on record to show skid marks of only one person. There is evidence on record to show that the bamboo door was not broken. And there is evidence that most of the bullet injuries have happened on the back and on the buttock. Is that when a man is running at you with an open gun, that he gets shot on the back and the buttock? No. There is prima facie material. We are not going to comment. but the reasons given are good enough, and there should be. You will be absolved. CBI will say, yes, he was a militant, yes, the incident happened this way, you will be absolved. Forever there will be a doubt that the state police investigated into its own action and closed it. If the CBI goes into it, you should not be opposing this. Because the CBI goes into it and found this was exactly the way they say it, you are absolved.
My lord, that is,
An outside agency gives you a clean chit. What better certificate do you need? Today there will always be a lingering doubt that my people gave me a clean chit. Huh? These two appeals, no. In the first matter, what is the miscase? In MCWA number 12 of 2023, the applicant seeks leave to appeal against a judgment and order of May 2, 2023, passed on WPC number 83 of 2015, which the applicant herein was not a party. Paragraph. The applicant claims to be seriously prejudiced by the order passed, by the order impugned, and by the relevant order, to the extent that such order has directed an investigation to be conducted into an incident of 2015 at the behest of the father of a person who was killed in what, according to the state and the applicant,
son, my lord.
was an encounter with insurgents. Full stop. Paragraph. WA number 13 of 2023 is the state's appeal against the same order. Paragraph. Since there is already an appeal that has to be looked into, notwithstanding the fact that the order directing an investigation may not have seriously prejudiced the applicant in WA so-and-so, in MC so-and-so, leave is given to such applicant to prefer the appeal, full stop, paragraph. The appeal is taken up for immediate consideration, paragraph. According to both the appellants, particularly the state, pursuant to information received, the police personnel in Pura
My lord.
took steps to deal with a situation where suspected militants with new recruits were apparently in hiding in what is that place called?
Ramba Dangri, my lord.
Ramba Adingre. Full stop. The police personnel took appropriate steps to gather adequate men and machines to reach the spot, and at about 3:30 a.m. on March 4, 2015, that's the date, is that?
Yes.
3:30 a.m. on March 4, 2015, they identified a country-style hut to be where the militants gathered?
The time is 5 a.m.
5 a.m. Full stop. Paragraph. The state submits that after the hut was surrounded, warnings were issued to the occupants to come out without arms, but such warnings fell on deaf ear. Full stop. According to the state, three persons suddenly broke open the bamboo door of the hut and rushed, firing at the police personnel. Full stop. It was in such circumstances that the state claims that the police had no option but to open fire, and one of the militants who was in the most advanced position sustained bullet injuries as a result of the police firing and succumbed and died immediately. Full stop. The state's version speaks of two others who had rushed out together with the deceased, but there does not appear to be any trace of such persons. Full stop. Paragraph. Apart from the cases, criminal cases instituted by the police authorities pertaining to the incident, the father of the deceased lodged a complaint to the effect that it was a fake encounter in which his son had been gunned down mercilessly by the police. Full stop. Pursuant to investigation in such case, nothing untoward was discovered, and a final report was submitted under section 178 of the Code of Criminal Procedure. 173 of the Code of Criminal Procedure 1973. Full stop. The father of the deceased then instituted WPC number 83 of 2015 in this court. Full stop. An interim order was passed on June 28, 2017 in such petition. The operative part whereof is found at paragraph 4 of such order, set out paragraph 4 from page 162 of the state subpoena. It appears that the district and sessions judge West Caro Hills, District and Sessions Judge Tura conducted an inquiry and filed a report running into some 25 pages and appended pictures of the place of occurrence along with markings thereon. Full stop. the conclusion of paragraph, the conclusion drawn by the relevant district and sessions judge appears towards the end of the final paragraph of the report, colon, next line, open quote, 36 full stop, dot, dot, dot. It can be seen that the source information about GNLA militants taking shelter was most probably a correct information, as the deceased was found trying to escape by running away and shooting with his gun at the same time, and the subsequent recovery of the demand note in his pocket, and also the recovery of two in figure, bracket, two in words, bracket closed, blank, B capital, blank, D capital, demand, and capital notes, as well as the detonator from his bachelor's dormitory, B capital, D capital, full stop. However, no comma, the presence of two other persons with the deceased who are said to have escaped could not be established. Full stop. The paragraph. Such report of bad habit of not giving a date.
No date.
Huh?
No date.
There's no date. Such report of the relevant district and sessions judge was considered in great detail by the writ court in course of the final hearing of the petition. Full stop. It is evident that the state opposed the prayer for CBI inquiry on the ground that the criminal investigation department of the state had investigated into the matter, and even the independent inquiry by the district and sessions judge Tura revealed that it was a genuine encounter based on accurate information. Full stop. However, comma, what weighed with the writ courts appears from paragraphs 46 to 48 of the impugned judgment and order dated May 2, 2023. Set out. Paragraph. Upon appreciating the evidence, including the account of an executive magistrate who arrived at the place of occurrence within hours of the deceased being killed, comma, the writ court was satisfied that there were two versions of the same incident. Full stop. Further, comma, the executive magistrate's description of the defunct country-made pistol that was discovered from near the body of the deceased, who still lay on the ground, head down, and the completely contrary reports of the forensic science laboratory in such regard raised a degree of suspicion, to allay which, an independent investigation could have been called for. Full stop. Paragraph. Indeed, the Red Court observed that notwithstanding the evidence of the executive magistrate who was present at the place of occurrence shortly after the shooting took place, the district and sessions judge apostrophe S, judges, reliance on the FSL report without discrediting the ocular evidence of the executive magistrate was somewhat irregular. Indeed, even if such aspect has not been harped on in the order impugned, the same is implicit from the discussion in the paragraph quoted above. There was further material for the writ courts to be prompted to call for an independent investigation, notwithstanding receipt of the report from the District and Sessions Judge Tura. Full stop. For a start, the executive magistrate present at the spot immediately after the incident reported that the bamboo door of the hut was not broken. Such an observation goes against the fundamental premise of the state police that the militants broke open the hut, broke open the door and rushed at the police personnel. Full stop. Secondly, several of the bullet injuries found on the person of the deceased were on his back and his buttocks. Full stop. Even if it is accepted that such injuries were suffered once he had fallen on the ground, and may have been the over-enthusiasm of the police personnel to ensure that the suspected militant was dead, there was enough material for the writ court to conclude that it was an overkill or excessive action. Full stop. Most importantly, the police version hinges on 3 persons rushing out and shooting at the police personnel. Full stop. If the rest of the police story is to be believed, that they had surrounded the entire area, issued warnings, there was little possibility for the 2 others to escape. Full stop. Paragraph. The observations herein will not prejudice the further investigation that has been directed, but the only object of the present exercise is to emphasize on the anomalies that weighed with the writ court to observe that there were different versions of the same incident. Full stop. Paragraph. At any rate, comma, even if it be accepted, for argument's sake, that it was a genuine encounter and the police personnel and the state police acted reasonably and rationally, comma, there remains a slur on the conduct of the state police since, comma, at the end of the day, it may be said that the state police itself investigated into an allegation of a fake encounter brought against it and gave a clean chit, full stop. It would be so much better for the state police if the investigation as directed by the order impugned is conducted by an independent external agency and the state police is given a clean chit by such agency. Paragraph. As far as the individual who has been granted leave to prepare an appeal is concerned, comma, the order impugned does not prejudice such person any more than it affects the state, full stop. If such person was a part of the police team on the relevant date, comma, the independent investigation by the Central Bureau of Investigation will bring things to light, and if no wrongdoing was committed by such person, comma, there is no need for any apprehension on his part. Paragraph. Considering the nature of the incident, comma, the material that was available before the writ court, and the grounds that have been clearly indicated for choosing, for requiring a fresh investigation into the incident to be conducted by an independent agency, comma, the judgment and order impugned do not call for any interference. Paragraph. A final ground is urged on behalf of the state to the effect that the parameters laid down for a CBI investigation into matters, despite the state opposing the same, parameters laid down by the Supreme Court, have not been met in the present case. Full stop. The fact that the police version is that the action taken on the relevant date was against extremists. The fact that the father of the victim and the local villagers have a different account of the incident, and the fact that the anomalies noticed by the writ court in the dispassionate account of an executive magistrate, which does not tally with the official version rendered by the police, comma, were good grounds for the writ court to require another agency to investigate into the matter. Full stop. There is no need for the state to harbor any misgiving, since, comma, if the police action was justified, comma, the investigation, whether by CBI or by any other agency, would reveal the same. Full stop. Paragraph. Accordingly, comma, both the appeals, that will get a new number, and so are dismissed, full stop. It is made abundantly clear that none of the observations in the judgment impugned or in this order will prejudice or persuade the investigating agency in any manner, will prejudice the investigating agency in any manner whatsoever, full stop. The investigating agency will be left free to conduct its own investigation, and the state and the allied agencies should cooperate in the matter so that the investigation can be concluded as early as possible and, preferably within, has a time limit been given?
No, no time limit.
Within 6 months from date, paragraph. A copy of this order will immediately be forwarded to the Office of Learned Deputy Solicitor General attached to this court for the same to be forwarded to the appropriate CBI personnel for necessary action. Paragraph, there will be no orders to cause.
Only in the first paragraph, I think, in the place of son, father is recorded. If my lord can just.
I will correct it.
Apology.
Okay.
Item number 2.
No. Mr. Patel, it's may it, not may I. Yes.
I stand corrected. I stand corrected.
Yes, what is this appeal about?
As per my lordship's order dated 1st of August 2023, the Slum Rifles have now passed an order, or I have filed an affidavit, my lord, showing that the status, basically the status of Writ Bill 10 of 2022 and the implementation of the order passed in WBC 198 of 2019.
Yes.
These were the two, my lord, that were queried. As far as the Writ Bill 10 of 2022 is concerned, my lord, in their affidavit, I find there is no specific mention. However, my lord, my information says that the SLP is coming up for consideration on 4th of September, my lord.
Very well. You are for the appellant? Yes.
My lord,
Since it is submitted on behalf of the appellants that a special leave petition arising out of one of the orders relevant for the present purpose is due to be taken up by the Supreme Court on September 4, 2023, let this matter stand over for 4 weeks. Full stop.
Deeply.
The paragraph, the parties will have liberty to mention for earlier listing, if the relevant Supreme Court matter is disposed of before the adjourned date.
Deeply.
Thank you. Done?
Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
Please, Lordship. From the online, I have checked that the person, the private respondent has received the notice. So I may be allowed to file the affidavit of service to bring on record because we have.
Very well, let the matter stand over for a fortnight, for a week.
Lordship.
The respondents must be informed of the adjourned date. The appellants should file an affidavit of service.
Lordship.
You are appearing for
Respondent 1 to 3, Your Lordship.
1 to 3.
Yes, sir.
Please record her presence. Respondent numbers 1 to 3. 3 respondents or more?
There's only 4, Lordship.
4,
1, 2,
very
3, and then.
Yes.
Item number 2.
What's first, Lordship?
Who is for the petitioner?
Lordship, may it pleases your lordships.
Yes, madam.
Lordship, the arguing counsel is on bereavement. Her mother has expired day before yesterday.
Very well. Despite the previous orders of July 13, 2023, August 8, 2023, and August 23, 2023, a further adjournment is sought on behalf of the petitioners. Full stop. It is recorded that the petitioners have been put on notice that in view of the availability of an efficacious alternative remedy, the merits of the present matter may not be gone into, and the petitioners may be left free to pursue the regular remedy. Paragraph. However, the cause for seeking an adjournment today is the bereavement suffered by arguing counsel. Full stop. Paragraph. In view of such position, let the matter stand over for a fortnight. Full stop. The petitioners are requested not to seek any further indulgence. Give it a date.
Maybe for 3 weeks, my lord, it's bereavement.
2 weeks when we say the date will come at 3 weeks.
Lordship.
Item number 3.
Deeply.
May it please, yours.
Yes.
This is the urgent matter, my lord. There was a discussion and negotiation with the parties, my lord, and government is contemplating to increase the area, my lord. So, possibly within 4 weeks we will have a solution.
Very well. This matter has still not been resolved, despite negotiations between the state and the respondents. Paragraph. Learned Advocate General submits that the state has agreed to extend the area somewhat.
Contemplating, my lord. Contemplating, my lord, because
The state is contemplating a request by the respondents to to provide some additional space, full stop. For such purpose, the state requests adjournment of the matter for 4 weeks, full stop. Paragraph. Let the matter appear on, give it after 4 weeks.
Offline.
Yes.
Item number 4.